Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk, which is entitled Organizing Successful Events, Legal Considerations. My name is Noelle Yong. I'm an associate with Wong Associates, and I will be your moderator for today's session. Now, before we start today's talk, let me introduce the firm and what we do. Wong Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today comprises 32 lawyers and a support team of 34. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. So by way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 movement control order, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Now, before I continue, please be reminded that this talk does not constitute legal advice, and in the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation, the details of which will be given at the end of this talk. We have 3 speakers for today: Sarah Sun, Tommy Wong, and Mira Mashor. Sarah will be the first speaker who will be speaking on the regulatory compliance, and thereafter Tommy will be speaking on contracts and agreements, and finally Mira will be speaking on intellectual property rights and data protection and privacy. And after the talk, we will conclude with a Q&A session. Now let me introduce the speakers. Sarah has completed her 9-month pupillage and is retained under the corporate and commercial department of the firm. And the second speaker will be Tommy, is a senior associate in our corporate and commercial department. He graduated with a Bachelor of Laws with first-class honors in 2015. He was called to the English bar in 2017 and admitted to the Malaysian bar in 2019. Tommy primarily focused on corporate and commercial matters such as mergers and acquisitions, joint ventures and collaborations, construction contracts, project agreements, licensing of IP rights, and regulatory compliance. Next, we have Mira as our third speaker. Mira is an associate in our corporate department. She graduated from the University of Malaya with Bachelor of Laws in 2020. She was then admitted to the High Court of Malaya in 2022. Mira primarily involved in corporate and commercial matters such as mergers and acquisitions, regulatory compliance, and drafting corporate agreements. Now, our top points for today, as I've mentioned earlier, regulatory compliance, contracts and agreements, intellectual property rights, data protection, and privacy. All right, so if you have any questions, please don't forget to type it up in the Q&A chat box and we will answer your questions towards the end of the session. I will now hand over the session to Sarah.
Good afternoon, everyone. Securing the appropriate permits and licenses is a fundamental step to ensure a successful event, avoid legal issues, and prevent fines. So here is the breakdown of the key areas that every event organizer should focus on to ensure regulatory compliance. Organizers of cultural festivals, corporate conferences, sporting events, entertainment, spectacles, and so on must be well informed about the common permits and licenses that they should obtain. For example, temporary events like concerts or fun fairs require a temporary entertainment license. In order to obtain this license from the local municipal council, organizers must meet set guidelines such as safety and security standards. So for a case study here, we have the Puncak Alam Fun Fair incident. This fun fair commenced operations even though its license application was rejected due to the failure to meet safety standards. 2 days after its illegal opening, 2 women and a child were thrown off a ride and suffered injuries as a result. The fun fair operators were investigated for operating without a license. If convicted, the consequence would be a maximum fine of 25,000 ringgit or imprisonment up to 5 years. Organizers would also need to acquire special licenses, such as music license. So when playing copyrighted music or performing copyrighted music, organizers need a music license from the appropriate music licensing bodies in Malaysia, such as the MACP, PPM, or RPM, depending on the music usage. For liquor license, the sale of alcoholic beverages during an event requires a liquor license from the local municipality. This is to ensure the adherence to restrictions like age limits or prohibition of sales to Muslims. Furthermore, for concerts and live shows performed by foreign artists, an application must be made to the Central Agency for Application for Filming and Performance by Foreign Artists, also known as PUSPAL, which is established by the MCMC. Organizers must comply with PUSPAL guidelines, which sets out the code of conduct and specified blackout dates when concerts and live performances are not permitted to be held. Non-compliance of such guidelines can lead to bans, as seen in the case of the 1975 ban. So in this incident, during a local performance last year in Malaysia, the frontman of the band kissed his bandmate and criticized the local anti-LGBT laws, leading to the band's blacklist and ban in Malaysia by PUSPAL. So this incident has caused the festival's cancellation and faced strong governmental backlash. For health and safety requirements, compliance with food safety regulations is also necessary for F&B sales, including proper hygiene, food storage, and labeling of ingredients. Aside from that, the organizer must also conduct thorough risk assessments to identify potential hazards before an event. A clear emergency evacuation plan has to be established, and the procedure has to be communicated to all the attendees, as inadequate safety measures may bring horrible consequences. For a case study, in 2014, 6 attendees at this music festival had died due to severe heat, choking haze, high humidity, and insufficient hydration. This incident has damaged the festival's reputation, emphasizing the critical duty of care that organizers must uphold. For insurance requirements, public liability insurance is essential for risk management in any event. In Malaysia, securing a public liability insurance is required for sporting events. While public liability insurance doesn't prevent incidents, it covers legal fees and compensation claims from injured attendees or damaged property. So this insurance is essential in managing potential financial losses, safeguarding the financial stability of the organizers. Next, we have a direct selling license. It will be required to sell products or services directly to consumers without involving an intermediary, such as wholesalers or retailers. So this license is issued by the Ministry of Domestic Trade and Cost of Living, KPDN. Finally, for environmental regulations, an event should have proper waste management systems, including adequate waste bins and disposal arrangements for both the event goers and the vendors, as it is crucial for maintaining cleanliness and compliance with local environmental regulations. An organizer should, of course, also be mindful of noise pollution and ensure that event music or announcement comply with local noise level restriction. So for now, I'll pass it on to Tommy to continue with section.
Hi, good afternoon, everyone, ladies and gentlemen. Thank you for joining us. And thank you to Sarah for the kind insights to the regulatory compliance issues and matters of organizing successful events here in Malaysia. So for me, I will be touching quite briefly on some of the necessary contracts and agreements that are usually involved when it comes to organizing events here in Malaysia. Now, first and foremost, why are contracts and agreements needed for organizing events? It's the same answer as every other thing, because various parties are involved. It takes several parties to make one gigantic or small event to be successful. So basically, when parties are involved, then you will have defined roles and responsibilities, and you also want to limit your liabilities when it comes to the performance of obligations by another party, which may then contribute to you being in breach of certain contracts. So there will be indemnification as well. Now, regulatory compliance, this was touched on by Sarah earlier. Contracts also help you manage risk, potential risk, and also provides you with financial security based on the limitation of liability, your payment terms, so on and so forth. Performance standards, that is obviously one key aspect of every transaction in this world, together with intellectual property rights when music, artist image, and also brands and logos are involved in, for example, concerts and even comedy clubs as well. Now, what are some common contracts and agreements that are entered into between the various parties involved in the successful organization of and operation of an event? These are the ones that I've highlighted, or we have highlighted for the purposes of this online talk, and we'll touch on these agreements and contracts shortly. So we have the venue rental agreement, we have vendor contracts, event planning and management contracts, sponsorship agreements, talent agreements. This is just a generic reference for the name of such an agreement, because you have entertainers, you have performers, and also perhaps you may have some key opinion leaders or KOLs or public influencers or social media influencers that you want to engage. Also, you have the advertising and marketing agreement. If, as an organizer, you are not undertaking the scope of advertising and marketing of the event that you are organizing. And last but not least, one of the most important ones is the terms and conditions for the event attendees and event goers. So let's begin. Now, the venue rental agreement, it may be called that, it may not be called that. Firstly, I think for every event that you organize or an event organizer intends to organize is to actually secure the location of the event. Now, when you secure location of the event, you will also negotiate on the rental fee of the particular premise or location. I think all organizers would agree that the rental fee plays a big part because it fits into the budget of profitability for the event organizer after having considered the cost of vendors, sponsors, performers, entertainers, so on and so forth. Having a venue rental agreement, it is also important to consider the parameters of what an event organizer or entertainer or any other party involved can or cannot do within the particular venue, location, or premise. Now, to ensure everything runs smoothly and is legally protected, security, cleaning, hygiene, all of these things will be also considered in the agreement if the particular venue or location owner or vendor is particular about these aspects of areas. So obviously that ties in with certain insurance policies that an event organizer may need to undertake for the purposes of the event that is being organized. Secondly, vendor contracts. Now, I think based on the several examples that Sarah mentioned earlier, I think Future Music Festival Asia is one. So these festivals have F&B vendors, right? Maybe decoration vendors, flower vendors, who knows? So these vendors and service providers actually cater for several event needs. So it is important to have specific agreements and contracts with the respective vendors to actually set out their scope, what they provide, what are the payment terms, and what are the standards of service that they're expected to provide. So these sets out obligations of the vendor so that the event attendees or event goers can actually enjoy such services or amenities that are made available during the event. Now, sponsorship agreements, I think this is particularly important for all events because an event would require sponsorship, as there may be excessive finances or funding that may be required from sponsors. Now, when it comes to sponsors, then obviously in exchange for the sponsorship funds or the monies that are coming in, what would the event or the organizer be able and willing to provide in exchange, such as, is it a promotional branding of such sponsors, such as placement of logos on brochures, flyers, or even the billboards, right? Sponsorship agreements specify terms between organizers and sponsors, provide financial support, in-kind support in exchange for some form of brand exposure or promotion. So this is the most common sort of transactional exchange that takes place for organizers and sponsors. Now, most importantly, when you go to a concert or event, I think, or we believe that the core of the event are the performers or the entertainers that have been engaged for the particular event. When organizers an event for Taylor Swift, you're going there to see Taylor Swift. So I think to actually set in place the terms and conditions for engagement of a particular entertainer or performer or a speaker or a comedian, it is important to actually set out what are the terms of payment, what is the payment amount, and also the payment schedule, the time limit that they are expected to perform, and any other intellectual property rights that may come along with, for example, a singer, for example, like Taylor Swift, image rights, intellectual properties relating to songs, music, publication of their image, so on and so forth. So talents and performers and entertainers are the core base of organizing an event. Lastly, what we'll talk about here is the terms and conditions for attendees based on our presentation slides. Most event organizers will set out a clear set of guidelines, rules, and terms and conditions for attendees, participants, and also ticket holders to observe at all times during, before, and after the event. Now, these terms and conditions can include terms such as the purchase of tickets, the refund of tickets, admission procedure, conduct and behavior during the event, list of prohibited items such as drugs, perhaps alcohol and dangerous weapons, and the limitation of liability when it comes to event goers and separating the risk from event organizers or certain vendors. There's also personal data protection because obviously when you take videos, voice recordings, and images, some of which may or may not infringe personal data protection, media and photography, health and safety, and intellectual property rights. Now, obviously, there have been various events that have infringed on certain terms and conditions, such as FMFA, when there were several incidents involving drugs and the passing away of certain or several event goers. Now, each agreement here that we have mentioned about is essential to securing a successful event being organized and operated in Malaysia. Now, when it comes to events, most of it are contributed by entertainers, performers, and the talents there. When they perform, these contents, these materials, the songs, the images are under the ownership of the talents themselves or perhaps their own agencies. So perhaps what I can do now is then pass the floor to Mira, who will be speaking on intellectual property rights for events and talents. Thank you.
Hi, thank you, Tommy. Good afternoon, everyone. My name is Mira Mashor, and I'm a legal associate in the corporate department of Wong Associates. So today I will be the third speaker for this talk. As a brief recap, Tommy and Sarah has gone over two talk points, which is regulatory compliance and contracts and agreements. Now, my part, I will be discussing on the last two talk points, which will be discussing the intellectual property rights and protection and how do these 2 points relate to event organizing. So allow me to start. So first of all, we have intellectual property rights. Now, why is intellectual property rights important when organizing an event? So first of all, what we should know is intellectual property is an intangible asset. So what does this mean? It means that IP does not have a physical form. It does not have it has a virtual form that is valuable based on its innovation, its design, and most commonly its reputation. So that is why we see brands go the extra mile to register and protect their branding because it can generate revenue for them. So how is this relating to an event? So IP rights encompass a variety of things. It can be unique event concepts, designs, decoration, branding, innovative elements, technological inventions, and the event itself. So obviously, when you want to design this, when you want to invent it, it takes a lot of time and effort. That is why a lot of people want to register and protect their rights. So moving on, one important event that we would see where intellectual property rights come in play is in sporting events. In sporting events, that an event that where intellectual property rights is important is in sporting events. Sporting events that are famous, such as the World Cup, the Super Bowl, gain exposure around the world. So that is why sponsors and organizers want to promote their brand or their product in the sporting events. So one famous example that is ongoing right now is obviously the Olympics that is held in Paris 2024. So the International Organizing Committee, if some might not know, is actually a non-profit organization. So how they can manage to organize the Olympic event is they use the exposure of the IP rights and use the revenue to organize these events. That is why the Olympic logos, the Olympic emblems, mascots, flags are all afforded extensive legal protection so that they can always make sure that the revenue generated for that is enough to organize the next set of events. So what are the types of intellectual property involved in sporting events? We have trademarks, we have copyrights, we have patents. So if we use trademarks, this is maybe a logo or a branding that is exposed and that is shown around the events. So usually organizers or even sponsors, even athletes will trademark. In the Olympics, some famous ones, we can see the logo, the 5 rings. The Paris one on the right, as you can see on the screen. We have famous ones such as the Olympics, Olympia, all have already been registered. Now, if we move to copyright, it's usually the visual content of the sporting event. So this can involve the broadcasting rights of the event itself, official pictures, official videos. So only those that are authorized by the IOC can be used. Now, if we move to patents, so this one may not be directly seen, but it can be seen in like innovations in sports equipment or sports technology. Now, moving on. So knowing all of this, how can we protect our intellectual property rights when organizing an event? So first and foremost, the most secure is to ensure that your intellectual property is registered. Now, in Malaysia, you can register your intellectual property with the My IPO. So you can either choose to do this by yourself or with a trademark agent or with agent. So Mawin do provide these services if anybody is interested to register the IP rights. The second way that you can do this is by entering into a non-disclosure agreement, which is an NDA. So an NDA is an agreement, a contractual agreement between two parties which can specify the confidential information that is being disclosed to another party. So this allows for the disclosing party to set out in what conditions and in what events can you use the confidential information that is being exposed to the other party. So in the event there is any breach, you can sue based on the agreement. Now, let me move to my next slide, which is we will be talking about data protection and privacy. So what is data protection and privacy and how is it relevant when organizing an event? So we usually hear these two terms, data protection and privacy, and how it is interrelated. Now, data protection is a legal mechanism to protect a person's privacy. The primary legislation that governs data protection is the Personal Data Protection Act 2010, which is the PDPA, and its subsidiary legislation. Now, how does data protection and privacy relate when organizing an event? It differs. More commonly, you can see when certain types of events where you need to purchase a ticket to attend the event and then you have to submit your personal information. That is where data protection and privacy laws will come in play. Okay, so some of the personal data that may be collected may include first and last names. So this is obviously for obvious reasons to register for the event. Second is the email address to send the booking confirmation and the tickets. Third is the phone numbers to send or communicate with the attendees. Or fourth is the payment information. When you make payment and then you enter maybe your credit card details. So this is to process the payments for the tickets. As you can see, all of this information is very personal. And if this information is breached, it can, one way or another, may bring harm to the certain individual. That's why it is the responsibility of the event organizer to make sure that all of this information is being collected and stored safely. Now, for example, I can give you a case study of what happened in the Brock University in Canada. So what happened in this situation was that this university used a third-party platform to allow students to purchase tickets for a hockey playoff. But then after they were notified that the third-party platform experienced a data breach, they immediately suspended all access to the platform and notified the individuals that were affected. So this all just shows the importance and the heavy responsibility that is given to the event organizers regarding personal data and data protection. Now, what steps can be taken to ensure compliance with data protection laws? So first of all, as can be seen in the case of the Brock University just now, if you are working with third-party platforms, you must make sure that these vendors are compliant. What does it mean by compliant? It means that they are complying with the data protection laws, they have enough security measures to make sure that there's no data breach to any other. The next one is that we can have a privacy policy in place. Now, what does privacy policy means? So privacy policy is a document that discloses how the organizers collect, use, and manage the attendees' data. So I think most of the attendees would have seen or would have viewed a privacy policy when you are surfing the web or when you are purchasing anything online. They will set out what are the terms and conditions, and at the bottom, if you agree, you will have to tick the box which shows your consent. So this is what a privacy policy is. It should tell you on how your data is being collected, how it's being stored, and whether it's going to be shared with third parties. And with that, I would end my talk for today and I will move on to questions. Over to you, Noelle.
Now we'll be having the Q&A session. We will now take questions from the participants who have posted in the Q&A chat box. For participants who have not posted your questions, you can click on the Q&A chat box at the bottom of your screen and you can still post your questions there. We will now start with the first question. The first question is, when we conduct an event, should we apply for all music license or any one of it shall be sufficient?
Okay, so now when it comes to conducting an event, when you are using music, I think first of all we have to establish whether you are conducting live performances or playing recorded music or both. Now, perhaps you may require licenses from all three regulatory bodies or organizations. If your event involves both live music performance and also recorded music playing in the background after the live performances whether they're taking a break or they have ended. So I think perhaps if we are able to elaborate more on our response, perhaps you could let us know which direction of your question you're actually looking at. Thanks.
Thank you, Tommy. We'll now move on to the second question. Are we allowed to issue any merchandise using the image of the athletes?
Hi, Noelle. I can answer this.
Okay.
Okay, so the question was, are we allowed to issue any merchandise using the image of the athletes? And we would strongly advise against it. Athletes mostly would like to decide on who you get to use the image, and most of them would commercialize from it. So it is best to first obtain the athlete's permission first before you can use the image on any merchandise.
Thank you, Mira. We'll now go to our next question. Do we need customers or attendees' consent if we use their picture or video for marketing purposes?
For this question, we think it is best to first obtain the customers or attendees' approval first before using their videos and pictures for marketing purposes.
Just to add on to that, that is also because even organizers or even engage management or advertising companies for the event itself would actually have obligations to protect the personal data and information of all customers and attendees of the event. Now, there have been practices where events, concerts, or whatsoever festivals have actually used materials that contain images or even the identities of these attendees and customers or whatsoever not. But ultimately, the best standard practice is to actually obtain approval or just to credit them, even if they have given approval as well.
Our next question, regarding the merchandise part, can we use Olympic theme in general?
Now, when it comes to merchandising part, whether you can use the Olympic theme in general, the general answer and the strong answer is no, because there are very strong intellectual property rights surrounding the Olympic IP. Furthermore, if you use the Olympic theme or any logo or brand pertaining to the Olympic brand and logo, you may also fall foul of any applicable counterfeiting of merchandises law and regulations. There have been vendors who have used such IP rights and they have been breaching IP rights and laws, but our strong position is that no, you should not use Olympic themes or logos of brands in general for your merchandises. Thank you.
Thank you, Tommy. All right.
We have one question again. For marketing purposes, a company will indicate that who is their main clients and display their logo. Is this allowed? Okay, perhaps the question is a bit vague. I would try and assume the direction of the question. I would believe that perhaps for an event, you may have had certain clients in the previous engagements, for example, maybe Genting or Sime Darby or whatsoever not, whether there are any legal repercussions or any consequences. If they're not sponsors of a particular event, there is also confidentiality obligations between an event organizer or a marketer or an advertiser with previous clients altogether, right? Now, when it comes to in terms of engagements and confidentiality obligations, it is first very important and essential that if you want to use their logo or the fact that they've engaged you to do their previous events or whether they are your previous clients or not, always obtain the permission in writing so that there is an express authorization and permission from them for you to display their logo and their identity altogether. I hope that answers your question.
We have another question from Nurul Aina. What is the legal repercussion for the performer, such as 1975, other than imposing fine to the organizer?
I think this is quite a broad question. Legal repercussions for performers such as 1975, after having done whatever that they have done, imposing fines to the organizer, I think also perhaps there may be a gauge of whether event organizers or the management team has been, to what extent, been negligent in carrying out or observing the laws or conditions of certain licenses that have been imposed on them. Legal repercussions, I would say that it is quite broad. It depends. It's not just a fine to the organizer. There are also repercussions for vendors as per the 1975 issue. And for example, like FMFA, after having I don't know if I can say this, but what has happened in FMFAs, the reported deaths over the few years of concerts and festivals due to alleged drug use, drug consumption, there is what we call a kill switch for the entirety of the event itself. So it's not just for 1 year, not just for 2 years, but forever, at least for the time being until further announcements have been made. So repercussions in general, we have to see it on a case-to-case basis.
All right, the next question. Can we use image from Google, for example, P. Ramlee or Tunku Abdul Rahman, other than celebrities to put on merchandise?
I think I will take this question. So for this one also, it's similar to what Tommy has explained. It really depends on case-to-case situation. You will obviously have to see whether, first of all, whether the image is copyright or whether it's royalty-free. Usually there is a note attached to the image. If it is copyrighted, you will have to obviously obtain the consent from the source of the image or the owner of the image itself, whoever took the picture. So yes, hopefully that will answer your question.
Now, the next question, how commonplace are sponsorship agreements?
Yeah, I think the question was how common are sponsorship agreements? In practice, there have been instances where sponsors have just sponsored X amount of money in exchange for a placement of logo, and that's it, finished and done deal. But there have also been instances where particular sponsors or big name sponsors have required agreements to be drafted, setting out the limitation and restricted use of certain logos, brands, and information to protect their very own corporate information and also brand rights. Now, to what extent are these restrictions of use of certain intellectual property rights or names or whatsoever not? Really depends on the negotiations and the parameters that have been set in stone for the event organizers by the sponsors. But overall, even if it's not a strong, comprehensive, definitive agreement between sponsors and organizers, yes, sponsorship agreements are quite, or rather very common in this industry, yes.
We do have another question. Are cancellation clauses favorable to the sponsor rather than the organizer?
I am not sure what you mean by cancellation clauses, but I would assume it's termination clauses altogether. It really, again, it really depends on how you draft it. There are instances where you terminate because of breach of contract, you can terminate for convenience, you can terminate for pretty much any reason that you actually incorporate into the agreement. But what is important is the consequences and effects of termination when the termination is being exercised by either or both parties mutually or unilaterally. So whether be it is favorable or not, if your legal advisor is not able to pinpoint certain effects or consequences of termination, then obviously the other party is going to have a better advantage on such effects and consequences upon termination or cancellation for the matter.
I think that is all we have. Okay, so before we conclude, I have a few announcements to make. Firstly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat box. And secondly, do follow or like our social media accounts. We are on YouTube, X, Instagram, LinkedIn, and Facebook. And also, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. So please fill in the form on our website. The link will also be posted in the chat box, or you may scan the QR code here, which will direct you to the form on our website. Now, to our guests, thank you for joining us. We hope you have found today's session informative and insightful. Thank you, everybody, and we will see you at our next talk.